One Florida mother is fighting for her son's right to kneel during the Pledge of Allegiance in first grade. When night court convenes, we'll separate fact from fiction in this case with our legal eagles. They're standing by, ready to present both sides. You're the jury, so stick around. The U.S. Supreme Court ruled today that the government must generally get a warrant when seeking cell phone records that automatically indicate when and where you're located while using your phone. The case originated when prosecutors were able to get that information from wireless carriers while investigating a string of robberies without getting a warrant first. By a 5-4 margin, the court held that the information does trigger the protections of the Fourth Amendment. Time now for night court. Inspired by his older brothers who knelt during the national anthem while attending a football game, a 6-year-old Florida boy did the same when his first grade class recited the Pledge of Allegiance. The boy's mother says she found out about the incident when a teacher texted her saying the class was learning to be good citizens, adding, quote, that we stand for the Pledge of Allegiance. The mom says the teacher's reaction took away her son's right to free speech. So she is suing for up to $75,000 in damages and wants a judge to affirm her 6-year-old son's right to kneel. So let's talk about it with our legal eagles, criminal defense attorney Brian Claypool and former federal attorney Emily Campagno. Thank you both for being with us tonight.
Thank you.
Thanks, Shannon.
Okay, so first of all, let's talk about that. Florida actually has a statute that talks about this. They want everybody to stand and respect the flag, but there is an opt-out. It says upon written request by his or her parent, the student must be excused from reciting the pledge, including standing and placing the right hand over his or her heart. And it goes on to talk about what is expected of students. The family says they didn't know, Emily, that nobody told them this opt-out existed.
Right. Well, the notice is inapplicable here, and that statute was dissected in the Florida courts, and they specifically addressed this issue. They held, look, it's basically a balancing test here, right? And the balance is that neither side has unqualified, unprotected or protected rights. And the court held, look, in the examples of mature high school students, in limited circumstances, they might outweigh the rights of the district and the parents and the school itself. But certainly in a substantial number of instances, specifically elementary and middle school children, those likely does not apply. And so here, especially without notice, ignorance is not an excuse whatsoever, and this is squarely held within the law.
Okay, now the school says this because the complaint's been filed. The school has now responded. They said, this district, saying the school board specifically denies that a first grade elementary student has an unqualified, clearly established right to kneel during the Pledge of Allegiance. There is a 1943 Supreme Court case on this saying you can't force kids to salute or to say the pledge. I mean, Brian, are we talking about the technicality of kneeling here? Is it about the student's age? How does this work?
Well, look, let's call a spade a spade. I think this is a legal loophole that the state of Florida has tried to implement with this law that you just read, or that Pasco County school district policy and this Florida statute. It is clearly at odds with this U.S. Supreme Court case that you mentioned, the West Virginia State Board of Education versus Barnett, Shannon. It is still good law, and it says one thing, that you cannot force, and it says any student to respond or honor any patriotic device. And then now you have a Florida state law that is now saying that kids must stand and they must place their hand over their heart and honor the Pledge of Allegiance. What they did is they created this little exception as a loophole to get around existing U.S. Supreme Court law.
Well, this is how the family lawyer responded. This quote is in the Tampa Bay Times, talking to him about the case. He says, I'd respectfully suggest that this is a bold assertion to be made by teachers and a governmental institution vested with the responsibility of teaching children about United States history and the U.S. Constitution. Emily, they're referring to the fact that the 6-year-old doesn't have this unqualified right to take a knee.
Exactly. To me, that was kind of a sensationalized reaction to what was clearly an interrogatory answer. I do understand Brian's point, and it's fair. But that being said, the statute is law right now, and until it is stricken down as unconstitutional, then those kids and the parents have to comply. And the bottom line is that there is a balancing test and a balancing factor that comes into play on school grounds. Neither side, again, has full unfettered access. These rights have to be balanced. And so especially in the instance of a 6-year-old child, the school's interests will likely, per the court decision that I referenced earlier, outweigh that child's desire to kneel during the Pledge of Allegiance.
I mean, Brian, how far do you think this goes? Because this Supreme Court case we've been talking about is from 1943. Yeah. Do you think it's time for an update? Because this is a debate that we're having all over the media the last couple of years. And kids are responding to, in this case, he looked up to his older brothers. His parents say his own convictions. But it's definitely a conversation we're having. Is it time for the court, the highest court in the land, to revisit this?
Well, that's a great point, because technically, Emily's correct. The U.S. Circuit Court of Appeals in the 11th District, they ruled on this issue. I think it was Frazier versus Wynn. But the U.S. Supreme Court in 2008, Ashley, they punted. They decided not to hear this case. Well, guess what? Hopefully this case will reach the U.S. Supreme Court. Because I think we need clarification. If I could mention one other quick point. Think about this, Shannon. If a 7-year-old child or a 15-year-old in 9th grade goes to their parents under this Florida law and says, hey, Mom or Dad, I don't want to honor the Pledge of Allegiance. Yeah, but my point is, you're taking the First Amendment rights away from the children and putting them in the hands of the parents.
All right, we want to hear from our jury at home. Brian and Emily, thank you both for weighing in. Let us know what you think on Twitter. How would you rule?